partner in the matter AIM Sport Division AG and Supponor Ltd.
Mr. Alexander.
My lords, can I start the points on construction with a few fundamental points that my lords need to bear in mind? And the reason for doing so is because, hearing my learned friend, some of the points I found quite hard to follow, given the degree of common ground that there actually is between the parties in relation to what the core inventive concept is and in accordance with which the judge construed the claims. So if I can just show my lords where we are in relation to that, to that issue first of all, and ground the case in the material that the judge was considering, it will then help the further submissions relating to the specific points on the claims.
Right.
So can I take this up with the skeleton on this appeal in paragraph 17 on page 24 of the appeal bundle, the core bundle. So in paragraph 17D, what is said, and we agree with this, is the apparent insight of the patent is to exploit the underlying well-known mechanism by which active billboards, i.e. those which display images by emitting visible light, e.g. LED displays, make their images. They only emit visible light in specific discrete wavelength bands across the visible spectrum, and we agree with that. Then there's a point that's made in relation to busyness, with which we differ, but it doesn't really matter greatly for the purposes of the case. That's the core inventive concept, or at least the issue that underlies the inventive concept. Then that goes on to say, and again, that there's no dispute between the parties in relation to this, right at the end, these real-world images remain visible in the detection image because, unlike the advertisements which are displayed by the LED billboards, they have very complex frequency response curves, and my lords will recall that that's a phrase from paragraph 34 of the patent, which is the key point embodying the concept, i.e. give off a wide range of frequencies, not all of which are filtered by the camera configuration. Now, of course, it is true that if one, in a sense, blacks out the light that's coming from the board, whether it be in visible spectrum or non-visible spectrum, that will have the effect of reducing the busyness of the background, because essentially, if you turn the lights off in the room, it becomes homogeneously black. But that's not what the invention is primarily directed to. It's directed to ensuring that you have a relatively bright image in front of a relatively darkened board. Now that point is in accordance with the approach taken in the expert evidence. And if I could perhaps just ground this by some very brief references to that, because one of the criticisms that was, one of the points that was made by the judge in paragraph 35 of the judgment was that although he didn't have any criticisms of the experts, he did think that the case that was advanced by my learned friends was a somewhat abstract one. So if one can ground this, it's in supplemental bundle tab 9, and if I can take that up at paragraph 130 on page 139 of the supplemental bundle, what is there being said, and again we don't detect any real difference on this, the EP663 distinguishes between static boards and active boards. In EP663, static boards have a fixed image that is painted or printed, whereas active boards are made from a display device such as an LED board. Active boards are further described in paragraph 34 as dynamic boards that can display multiple advertisements over time and typically can display static images as well as moving videos. And there's a footnote to the fact that Nerity uses a similar terminology in a slightly different way. Passive is used instead of static to describe boards having a fixed image that's painted or printed. And my lords will recall there was some reference to an ice hockey picture in my learned friend's submissions. As we understand it, what is being displayed around the outside is a static board in the sense of an ordinary painted board of the kind that one would find at perhaps football matches in the 1960s. And the concept, therefore, is one of a contrast between a board that is active in the sense of giving out radiation and static in the sense of, or non-active in the sense of merely being passive. And of course, as my lords will have appreciated, that's entirely in accordance with the disclosure of the invention in the patent in paragraph 2026, paragraph 34, as is subsequently explained. And if I can perhaps just draw my lord's attention to that for 2 points in some further paragraphs in this evidence. And the 2 points are these. Severe criticisms are levelled at our side for advancing new points on this appeal and referring to figures that apparently we oughtn't to have referred to. These were figures and points that are referred to in the very paragraphs of the patent that the judge considered, and you will have had my little note in relation to that, and were referred to in the evidence and skeleton arguments. Second point on this, and the more substantive point, is that what this section does is it describes the concept, actually in much the similar way to that I've just shown you in my learned friend's appeal skeleton. And that's why we say there's a good degree of common ground in relation to this issue of receiving radiation from the object and trying to suppress the radiation at the rear. Did my lord have a question?
No, I'm contradicting what you're saying.
I'm sorry, I thought you. Yes, I'm sorry, let me just give the paragraph references. It's paragraph 147 to 155 of supplementary bundle, tab 9, starting at page 141. And my lords may want to read that now. I'd suggest that we don't take up time on this because it really repeats material that we've already put in our skeleton argument. It explains it in slightly greater detail. But for my lord's note, we respectfully refer you to this. May I make a few specific points on these paragraphs, though, so that you have them in mind. First is in paragraph 150, where what the skilled reader would understand is that the camera that captures the detection images is equipped with a special spectral filter, which allows light only within a small controlled frequency spectrum to pass through the sensors, so that light from any images appearing on the LED screen is then excluded, and the skilled person, it said, would understand that in the detection image, the pixels representing the display board would appear as a solid, uniformly dark region, due to this elimination of radiation from the display board, and because LED screens are typically designed to be monotone, uniform, and dark when not active, so that they have a good black level. So there was quite a lot of submission from my learned friends about the possibility of boards being white boards. That's simply not the concept of the patent at all, in the sense of boards that are emitting light. The whole point of these boards is that, like a computer screen when it's turned off, or a television screen when it's turned off, it's going to be a dark, non-active board which will have a background against which things that are relatively illuminated by the ambient light will show up because of the spectrum that is available coming back to the camera. So that, as the paragraph goes on to say, i.e. so that they can portray images including black or dark areas. And in a sense, it's kind of obvious if you've got an active board and you want to have blacks represented as colours, and the board is an illuminated board, you need the base colour essentially to be black, so that when nothing is turned on, you've got something that appears black to the naked eye. Then, finally, as explained in paragraph 34, the detection images captured by this setup will not be influenced by any changes displayed on the LED screen. And then the next point is spectral bandpass filter can be chosen so as far as visible light. Alternatively, the spectral bandpass filter can be applied and arranged in the non-visible part of the spectrum as explained in paragraph 35. And my lords have picked up that point. The final point from this section, and again, we don't really detect that there is any material disagreement in relation to that, is in paragraph 155 on page 145. The basic image property, there was some discussion of that, utilized by EP663 system, thus includes, at a minimum, the intensity of the light received in the detector via the spectral bandpass filter, which for each pixel is either bright, where it corresponds to a reflection in the detection frequency from an occluding object, or dark, where it corresponds to the absence of light in the detection frequency from a display board. And that is a way of seeing the claim which makes sense of image property. What could be more of an image property than its, as it were, illumination characteristic, as compared with a board that has relatively been blacked out. So that's the material which we respectfully submit is something that my lords should have in mind, because it isn't really a difference on that matter. The final 2 points that my lords may want to have in mind before we get to the claims are, first of all, a point that I just referred to in passing on Nevity Plus. I know it's not a matter before this court, but it is useful for my lords to bear in mind what the argument was in relation to that in what follows, because our overall submission is that essentially what was going on here is that the defendants realized that their Nevity system was fine but had some shortcomings in relation to a situation where you had bright ambient light. And the reason, the way which it was put to me is it's very difficult to compete with the sun if you're a torch, if I can put it like that. So that if you're trying to distinguish things that, and that's true across the whole spectrum, not only the visible spectrum, but also IR spectrum and so on. So once you get to a situation where you've got board, where you've set things up so that the board is illuminating, and you're identifying your board in that way and trying to identify the occluding objects in that way. And you've got particularly sunny days, possibly at certain times of the year, or whatever, or even in circumstances where you've got an illuminated stadium that is illuminating across the spectrum, you might find that there are difficulties. And so essentially what we say, and the judge in essence held, the defendants did, was to say, well, okay, in that kind of situation, we're going to not have a situation which tries to identify the occluding objects by seeing whether there's a board there and having the objects appear relatively dark in front of the occluding, in front of the board, but actually have a filter that then filters out the board, or selectively filters out the board, having the illumination on the player, or whatever it is, in front of the board, which is the alternative approach. And the way that they do that is by their ratio analysis. And what the core of the argument was in relation to the inventive step was, well, it would be obvious to do something like that once you had Nevity, and therefore you fell within the claim. It was like an argument almost that that the SVB system was itself obvious over Nevity. And that argument was really roundly rejected and is not sought to be resurrected. And can I just refer, my lords, very briefly to a passage on that, so that you have it in mind also when considering Nevity OD, because the argument there was a somewhat somewhat different point. We can take that up from the judgment at tab 8, page 128. He there summarises Supponor's arguments and the reasons why why he doesn't find them persuasive. And the essential elements were boiled down to this. Skilled person would realise the Nevity system was a form of IR chroma keying, and my lords will appreciate what IR chroma keying is. It's essentially you create a colour, a uniform colour field behind the usually weather person, and then you can use that to create your mask. Skilled person would identify the potential problem posed to the Nevity system by bright ambient sunlight, and we agree with that, although the judge was right to say, as he said in the earlier paragraph, that the expectation of practical problems would be a provisional and a rather general one. And then the next step in the argument was that the skilled person would appreciate the problem was precisely the same as the CGK issue, and having appreciated that, the skilled person would know the solution for visible light chroma key, which was to add another IR channel. In this second IR channel could be used, and that point was then advanced. And the judge said, well, I agree with the first of those points, and Dr. Thomas had said as much, but he was using chroma keying in the broad sense when referring to Nevity, and didn't accept that by analogy or extension, the skilled person would make a connection to visible light chroma keying, i.e. in terms of the problem or the solution. I return to other aspects of the evidence below. And then there was a long section in which the somewhat artificial argument that was advanced, which was to say, well, what we are doing was obvious over Nevity, was developed, which actually wasn't in any of the expert evidence and appeared to be a construction. So that was the basic battle lines. And the reason the battle lines are important also in a sense for the construction argument is because at this point, it's actually almost common ground what the core inventive concept is, because what you're trying to say is, well, actually, what it would be obvious to do is to do something along the paragraph 34 lines on the basis of Nevity Plus, which assumes that you've got an illuminated object in front and a blacked out board behind you. And so here again, even the defendant's case in relation to the patent involved, we say in a sense correctly, taking on board the fact that this was the concept that they were really having to attack, and that was their primary point. Final point in relation to that, and I think I probably don't need to read it out, at least I'm not quite sure what's confidential here, but it's just so that my lords have in mind the issues on the bright light, non-bright light situation from the PPD, which is supplementary bundle, page 60, so that's tab 3.
If you tell us what paragraph.
I'll tell you, I was just checking the confidentiality issues, I'm sorry, my lord. The two paragraphs that matter for the purposes of the PPD are paragraphs 25 and 29. And my lords will note that the PPD doesn't contain the diagram that the judge looked at in the patent and my lords looked at yesterday. That was something that I think came from the other side in argument by way of exposition. It doesn't matter for present purposes because the judge said, actually that's quite a convenient way of looking at it, but the issue on OR gates and so forth didn't feature. And so my Lord Justice Burst said, I'm not quite sure I understand the OR gate. And it was a fair point because you might reach for the PPD at this juncture. Say, oh, well, the OR gate will explain the precise circumstances in which one route is taken rather than the other route is taken, because one might expect that to appear in a PPD. Well, it didn't appear in the PPD, and so that's why neither I nor my learned friend is able to assist you on the precise functioning of that alternative, and why the judge was also able only to say, well, we know that it's going to work in the, let's call it the IR channel 2-way, just as a shorthand, some of the time, because it is specifically designed to do that. What we cannot determine on the basis of the PPD material or any of the other material in the case is precisely the circumstances in which it operates in one and the other. And if I can just explain the possible issues, I don't think it really matters for the appeal, but for example, one could set up a situation where at a given level of illumination, let's say dawn or dusk, you could change from one system to another, or you could do it on a more local basis. That's why we use the term handover. But we're not saying that handover is itself a term of art, or it's a term used in the PPD. It's only used as an expression to encapsulate the concept that the judge recognized and is specifically recognized in the PPD of the fact that in certain circumstances it will operate in the nevity mode, and in certain circumstances it will operate in the infringing mode, or what we say is the infringing mode. And so focusing on the two paragraphs in issue, it's 25, really 25C, where you have the point after the or, the top of page 60, or the ratio of the brightnesses determined. And then in paragraph 29, what is said in the second sentence is in conditions under which there is little ambient IR, for example, during nighttime events or events at indoor venues, the SVB may be configured so the step referred to is whereby a pixel corresponding to the area of the expected board position corresponds to a visible part of the LED board is determined using only a comparison of the brightness of the pixel as observed by the first IR camera. That may be the case. And so it is consistent with this PPD that the, I will call it the infringing alternative, the alternative that's held to be infringed, is switched off in the conditions identified in paragraph 29 of the patent. But what we can't tell from this is anything really more than that. And in a sense, you could envisage that not being a irrational boundary to draw. You say, well, when there is, one thinks about this in terms of, let's say, very basic binocular use. When there's plenty of light, if you're whatever in the army, you use an ordinary binoculars. Then when the light goes down after a certain point, you say, oh, well, I'm not going to use ordinary binoculars, they're useless. I'm going to use infrared binoculars. So you've switched to an alternative method of picking up the relevant signal. So I just wanted my lords to understand why there was that hole in the understanding, and it's not because the parties have, at least not on our side, don't have an couldn't have an answer to it. It's because no answer has been provided by the other side, but it doesn't matter for the purpose of the case.
You said the conditions identified in paragraph 29 of the patent. You mean the PPD?
Oh, I'm sorry, the PPD. I'm sorry, I misspoke.
I see. I was a bit confused.
So those are the key background points, and once one's got those in mind, perhaps I can then turn to the judgment and how the judge dealt with these points of construction and respond to the criticisms that are made of it. Again, we would submit of a somewhat vague and in some cases nebulous nature. So we can take this up at page 117 of the core bundle. And before we get to the words of the claim and the construction in context, it is worth bearing in mind a few points that the judge had in mind, which your lordships may have picked up in the submissions yesterday. First, he recorded Supponor's argument that the claim feature required higher order processing. And he said, and we respectfully submit that he was right to say, and you can see it in the way the argument has developed before you, that no categorical definition of higher order processing was put forward by Supponor, and a range of expressions was used in evidence and argument. He then referred to what Professor Steed had said, namely that an image property of a detection image whose presence can be associated specifically with the presence of an expected type of excluding object identified by the detector. Then the argument went that that would require some pre-existing overall appreciation of excluding objects' likely appearance. It doesn't extend simply to looking at one pixel at a time, isolation, see how bright or dark it does. And then he records Ames' argument and the issue on breadth and the points that have been debated. One point, though, on breadth is that this is not quite a case where one's looking at the issue in terms of might be called pure breadth. So you've got one dimension of scope of claim where there is a narrow construction and a broad construction. Our submission is, and it's really why these points go together, is that the construction that we say the judge rightly adopted was one which comported with the inventive concept of the patent at the level of generality at which the inventive concept of the patent was described in the patent. And that is in paragraph 34, 26, and so forth. So, although one could say, well, in some respects it's broad, it's not right to say that it's broad. What it is perhaps better to say is that it is encapsulating the inventive concept without reading into the claim additional features which may be used with the invention of the claim that are narrowing additional features. And that approach to construction of a claim of a patent is absolutely orthodox. It's not a question of breadth or non-breadth. That's what one is supposed to do in construction of a patent in our respectful submission. So the judge then said he thought it was relevant to consider features 12.3, 12.3.1, and 12.5 as a whole. And my learned friend said, and we really don't understand it, that the judge didn't consider the features as a whole. It's one of the criticisms that he makes of the judge. But the judge is here saying that he is considering the features as a whole, and it is perfectly clear from what he went on to do that that is exactly what he did, because when he was looking at the feature of the first feature in relation to higher order processing and the image property, he was looking, as he correctly should do, the features of the claim 12.3 and 12.5 together. He then made the point that words are not terms of art or even very technical, ordinary words, and then there's the main relevant context, which he recites and which you'll be familiar with, so I don't need to go through all of that. Then in paragraph 128, we're not included in claim 12, the word descriptor is mentioned in a number of passages. It does have a technical meaning going beyond the ordinary English meaning, as was set out in the statement of agreed common general knowledge, but ultimately it didn't matter for the purposes of the argument. So then he recited the arguments, and the argument is, if one might also follow my earlier point as to the point on narrow, what he was saying is an argument that involved reading into the claim features of the claim that require additional image processing, or in some parts of the argument on the other side, only particular kinds of image processing other than those that are the inventive concept of the patent, or the core inventive concept of the patent. So he recites the points, records the fact that the arguments on those points are a little bit changeable in paragraph 131, and the other points. And there is a point in paragraph 133 which is quite important, and again reflects this position of common ground as to what was regarded as the concept of the patent. Right at the end, where it was said that aspects of the claim would be essentially claiming something that was conventional if it was construed in the way that the defendants would wish. And the judge recorded correctly that the reader would not in any event think that the totality of what was described in 34 was conventional. And quite rightly so, because as we have seen, that was not conventional. Indeed, that was the whole insight of the patent, was in those parts. So there's a somewhat odd consequence of the approach that my learned friends take to construction, is that they say, well, what the patent is claiming, specifically primarily directed to, is that which is conventional aspects of the prior art, and is not directed to that which they themselves agree was the fundamental insight upon which the patent is based. And we say there's really no basis for that. So the judge then analyzes this point, image property, and we respectfully submit entirely correctly. He says, in my view, Supponor's argument image property is limited to higher order processing is wrong. Image property is a broad term, and the skilled person's first impression of the patent would be that it was very general. Goes on to say the skilled person would know what a descriptor was. General could include a spatial frequency descriptor of the kind described. But that's not at all the same thing as he says in paragraph 36, again, completely correctly, that spatial frequency analysis descriptors or higher order processing must be used. And he points to the language of the specification and the points on Claim 2, where my lords will have picked up that Claim 2 is potentially more specific. So one could see this as saying, well, you do the invention of the patent, and then you can add to that the other forms of image processing if you want, some of which may or may not be conventional, which are articulated in Claim 2. And again, an entirely conventional and sensible approach to construing a patent in accordance with the inventive concept that it embodies. And so then he continues discussing the stereo image approach and the point in paragraph 139, active board section does not refer to image property, where the phrase is used for a stereo image approach. And he says, quite rightly, I don't think there's anything in this, it's a very semantic point. Image property just means a property of an image. And in paragraph 34 refers to an image multiple times when discussing characteristics of what is captured by the setup in terms of frequency use. And so the point on the claim as a whole is really a very simple one, that you have in 12.3 essentially the detection of the relevant radiation once you've suppressed the background, and in 12.5 you have the concept of using that so as to identify the or detect the occluding object. And that is the most natural reading of the claim. And in consequence, the judge rightly rejects the argument for Supponor in paragraph 140 that if 12.5 meant what it said, then it was redundant and added nothing to feature 12.31. And he doesn't accept that, and he is absolutely right not to accept it, because the claim doesn't really make sense if you think about it in that way. Feature 12.3.1 does indeed specify the camera, and frequency selected is a fair paraphrase. That's pretty obvious from that integer. Feature 12.5, however, specifies the processing and so relates to something different. What that is doing is processing the material, to use a neutral term, from the camera so as to identify and detect the occluding object. And he says it's true that in a mere brightness active board, set up the processing will be very simple given what the camera does, but doesn't mean that feature 12.5 is redundant. What it's saying is that that's what it's directed to doing, that's what the integer is there for. And why does it make sense? What the whole object of the claim is, as anyone would recognize, is to set up a mask. So what you're doing is saying what we're doing is setting up a system which will identify the occluding objects ultimately. And so it's not really surprising that you have in the language of the claim language that says that the occluding object will ultimately be identified using the methodology in question. That's what the claim is directed to. And so 141, he summarizes the points. Where he reaches the conclusion that image property is broad. And we respectfully submit that while he was quite right to use the term broad, actually what he was getting at was prima facie meaning what it says, and not to be limited by reference to a non-specific, difficult to identify further set of other characteristics of an image in Claim 1. So to that extent, it was not a broad construction, it was a construction that's entirely in accordance with the concept. So that's the first point. Second point, dark on light. And again, all of the points are correct that the judge identified, and if indeed he did a parsing of the claim and the specification that was a detailed parsing. So let's just look at that a little bit. Not relevant that in rejecting Ames' argument would run it in naivety. The skilled person would have that in mind. That's a perfectly conventional way of construing a patent claim. But again, stating that its drive on the first aspect of feature 12.5 was that a broad meaning was intended. Well, we would respectfully say that although that is kind of an argument, this is a different dimension of breadth or non-breadth. It's a very general point to say, okay, well, because I'm taking a meaning that is the prima facie meaning and not narrowing it, I should also adopt that approach in relation to other aspects of the claim. But the killer point on this is in 3. Both sides agreed that the teaching of the patent was about processing radiation from the occluding object. And I've shown, my lord, the points, and you've seen the points in the note on that. I think we need to go to that. Consistent thrust of its teaching, common to the fairly general disclosure, paragraph 13 to 21, and the 3 more specific sections. Conversely, there is no teaching about using the absence of radiation from the occluding object. And I think we got to a position yesterday, after some pressure from the court, where that was accepted. So what is contemplated by my learned friends is that one construes this claim in accordance with absent teaching from the specification, but not in accordance with present teaching from the specification, which they say is the core underlying mechanism by which the subject matter of the claim works. 5, although I've said image property has a broad meaning, the context also includes detecting and occluding object. I don't think it would be a natural use of language to say something is being detected when it cannot be seen at all. This is fortified by the way that feature 12.3.1 is written concerning the camera to detect radiation outside the one or more predetermined frequency ranges, i.e. not radiation in the range emitted by the display device. Dark or light situation, one would naturally say that the presence of the occluding object was inferred but one would not say that it was detected. And it's quite right to say that's kind of another way of describing the technical issues above. And so on that aspect, we respectfully say that the judge was entirely right. Now, there were a few points that were made in relation to the possibility of a referee's trousers being of a sufficient level of darkness that they might not show up in that kind of system. That is not an appropriate way of construing the claim, nor, as I've shown my lord from the evidence, is it something that one of the leading experts in the field thought was a way that would make sense to say, well, the approach should be fundamentally different. Moreover, one needs to be a little bit careful with these kinds of examples, because something along those lines, you might say, well, that's a point of detailed evidence, or you say, well, actually, this would be completely illogical, not just a matter of submission on the part of counsel. And part of the reason for that is, if one thinks about, if I can put it like this, black on black, it's not always the case that it's not possible to identify from the reflected object from something that is in front of a black background, something that is also either a different color black, or because it's reflective, it might be shiny or whatever, nonetheless has exactly the complex spectrum that would enable it to be identified, notwithstanding the fact that it was, in some circumstances, uniformly black. I mean, I would accept that if one takes a kind of Anish Kapoor Vanta black, then it may be that is something that doesn't emit any radiation, but I'm not sure that how many referees' trousers are painted in that colour. And this is, in old language, what might have been, it's not so much a puzzle at the edge of the claim, it's kind of thinking about circumstances in which there may be, that the system may be slightly imperfect, is no more, it's just not rational when one's thinking about an image processing system. One can always think of situations where, in broadly speaking, image processing, a system may struggle. Indeed, one sees this even in Nevity. That's the whole point of the debate in relation to that. There are circumstances in which a image processing system would struggle in that context. That is not a basis for saying, well, we're going to completely overturn the fundamental agreed approach as to how the claim should be construed. It's just not a sensible approach, and that's been elevated to really the key point in the case, and we say there is simply nothing in it.
The judge criticised. Sorry, Mr. Nicholson criticised the judge for referring to processing radiation.
Oh yes, that really is an unfair criticism, and perhaps I can show my lord why it's unfair just by reference to the claim of the patent. If you go back, because it's recorded in the judgment, to, well, we can take it from page 115. Integer, and if one looks at integers 12.3 and 12.5 together, what you have there is a capture of at least one image with the camera in that way, and 12.3.1, wherein the camera is used to capture the detection image. And you could say, well, capture that itself could be described as, to a degree, processing radiation from the occluding object. And the reason I say that is because if one's thinking about an electronic camera system, what you need is to convert the relevant radiation, doubtless into some digital representation of it at that point. You're not, as it were, using the light directly. You're going to be doing something to the light. So even at that stage, there is an element of processing. But if one then looks at integers 12.3 and 12.5 together, what you're going to need to do is to say, okay, well, I'm going to identify that this is a occluding object and this is not a occluding object using a relevant comparison between the brightness of one pixel and the what you're expecting otherwise. And so that too involves an element of processing. And as the judge recognized, and the passage that I referred you to in 140, it is true that in a mere brightness active board setup, the processing will be very simple, given what the camera does, but that does not make feature 12.5 redundant, because what you're doing is then taking the material from the camera and then using it to create the overall mask. So although you might say that the judge could have used the term detecting, probably the most precise way of using the language in this context would be detecting by processing. And so that's why we say that...
So it's using the data obtained from the capture
correct.
in order to detect the occluding object.
And we do not say that that can be criticized by being described as processing. Yes, indeed. My attention is drawn to the fact that similar language is used. I don't think we need to turn it up in paragraph 188 of page 188 of the supplementary bundle in Professor Steed's evidence, where he refers to similar considerations apply when processing the output of a detector, which selectively detects only certain wavelengths of light. So, in our respectful submission, that is just not a fair criticism of the judge. What he was trying to do was to get at the underlying concept of what was going on, and he reflected it fairly in paragraphs 140 and 141. Does that sufficiently answer my thoughts?
Yes, thank you.
So, in summary, we say that the construction of Claim 12 that embraces a detection image in which the occluding object is identified by virtue of its being darker than the billboard in the detection image is inconsistent with the core teaching of the patent and inconsistent with what everyone recognizes is that teaching. That construction is one that is inconsistent with the patent, what the patentee is contemplating as the paradigm case of use of RGB LED displays, inconsistent with how the skilled person would expect a system of this kind to operate in practice, with a dark board, as I've shown you, and it doesn't make any sense against the background of an overall concept where the claim requires an active board where there is light emitted by the display device, which is deliberately then suppressed so that relatively the figure will appear bright or detectable in front of the board. But just on that point, there was some discussion about situations where there was no board. We don't really detect any relevance of this to the present case because the claims in question, if there's any dispute, relate to an active board. And that's the whole point of integer 12.3 is one where you've got a board that is active that can be suppressed. So there's nothing in that point either.
I thought it was also put that not all the light from the board will be suppressed.
Well, it's true that not all may be suppressed, in the sense that in the real world, probably if one thinks about these filters, they may not be able to cut out absolutely everything. Just as, but if one thinks about, I'm not quite sure what my Lord has in mind. So it may be that if one's applying a filter.
Well, I thought, sorry, maybe I misunderstood, but I thought the point is that what you are excluding is the moving image.
What you're excluding is the light from the board, the LEDs.
From the moving image.
Well, yes, but it's only the LEDs that create the moving image.
Well, you may have a... So what is the difference between a moving image and the LED display?
None. If one thinks about this in television terms, or indeed computer screen terms, a computer screen displays either static or moving images. It displays static or moving images in exactly the same way, namely by using pixels that are RGB, I think they're all RGB pixels on a screen. Now, it may do so in slightly different ways, in that in some of the screens, and I'm afraid I'm not an expert in screen technology, but in some screens it may do so by having the pixels always illuminated and then having a liquid crystal in front of them, which will essentially black them out. So you can selectively illuminate given pixels in an array because you've got a mask over it. Mm. In others, let's take a paradigm example of a cathode ray tube, where you're actually illuminating particular points on a cathode ray tube. The color or the light on a cathode ray tube or a billboard or whatever is created by the combination of pixels, and that is say whether the image is moving or static.
Well, that's why I wonder why 12.1.1.2 refers to a moving image. Why does it matter whether it's moving or static?
On that, it doesn't matter because the method in question is configured to display a moving image. Yes, it will be configured to display a moving image, but that's not because it can't then also display a static image. In that you can have a billboard that is...
The display, the point is that of the display, it will either not appear because it's not illuminated, or it will be blanked out because it is within the predetermined frequency ranges.
Yes, that's correct.
So basically you're blanking it all out.
Yes, that's correct.
Whether there's an image there or not.
Correct. Well, you're blanking it all out, whatever the nature of the image. But the screen in question is one that is configured so as to be able to display a moving image. Now let's consider this kind of situation where you could have a billboard. Let's take a stadium that had around it an array of, let's say, laptop screens. You could arrange that so as to display entirely static images. So that,
and for some of the time they do.
And some of the time they do. But once you've got a laptop, then you can obviously also do moving images. What this is getting at, or that part of the claim is getting at, is to say, well, we're dealing with active boards that are capable of displaying moving images, in contrast to static boards or non-active boards, such as a flat billboard.
The difference between active and static isn't concerned with whether the image moves or not.
No. It's whether the distinction is between whether or not the screen is just like a notice in the courtroom, or is like a computer screen or screen that's composed of pixels that is capable of displaying a moving image. And the consequence of selectively blocking out the frequencies from the pixels are that you will remove all images, moving or static, from that kind of board.
I suppose if you had an old-fashioned stadium, perhaps in the early stages of the FA Cup, which was configured only to display static images, but the broadcaster wanted to use this invention to display moving images to the broadcast audience, there might not be any infringement because integer 12.1.12 would not be satisfied.
Well, first, your lordship is right on that, but the point is a slightly different one. The reason, I mean, that would be maybe a reason, but there would also be a more fundamental reason, which is that you think of an ordinary notice, a flat notice, that's not comprised of pixels. I mean, it's a feature of these visual displays that you're creating images of a whole full color range, including white, by having the eye unable to identify at a distance the fact that what's happening is essentially the confluence of colors from individual RGB pixels. And so what you don't have in a ordinary notice is these sharp frequencies that you can then suppress. So if I give an example here, if you're trying to think of something that is static, if I were to suppress just the frequencies in accordance with the diagrams that you've seen, I'd still have billboard. I mean,
yes, I see that.
Behind me. In fact, in some ways, the reason that you can identify the player in front of the dark billboard is because players' shirts are like traditional posters. They're not just made up of individual pixel emissions. And so they will emit over the full spectrum. And so even if you block out that particular R frequency, that particular G frequency, and that particular B frequency, you're still getting stuff from the rest of the shirt. Yes. Does that sufficiently answer my lord's?
I understand what you're saying. Question.
Yes. 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 I mean, it's the reason I'm hesitant to get into this at a level of technical detail is because I don't know exactly how all of these boards work. So some of them might be backlit, for example. So you've got a kind of filtration system of the colour. So if you can imagine, printed sheet with a light bulb. Yeah, that wouldn't be. That's not capable of displaying moving images. So in our submission, the judge was right on those key points. And the consequence of him being right on those points means that he was also right to say that amendment of the claim was not necessary. Unless my lords have other questions for me on those 2 points on construction, I was going to move on briefly to amendment.
I do have one question. On 12.5, I hesitate to ask because it has a nasty habit of setting a hair running, but it's bothering me, so I'm going to get it off my chest. in feature 12.5, it reads detecting number and occluding object, at least partially occluding the overlay surface in a selected captured image, offset at least one captured image, based on an image property of the occluding object and the detection image. What does this? Is it? What's this and? What's the end there? Why does it not just say occluding object, which is what we seem to be everyone seems to be treating it as if the words and the detection image aren't there, and I don't understand what they're doing, and I don't.
Oh yes, I understand where my lord is coming from, and I can also understand why no one has really focused on this, and there's a very easy explanation for it. If one looks at 12.3, 12.3.1, what you're doing is setting up a camera to capture the whole of a detection image, essentially. So if you're then trying to detect an occluding object, what you're trying to do is detect the occluding object, one could say, in the detection image. Because what you're trying to do is detect the occluding object against the background of the detection image. And so you always need to, I mean, in a sense, you're always, when you're looking at something, trying to look at a thing in front of another thing, if I may put it in that way. Yep. So what you're doing is then saying, right, now you've got your detection image, you've got your occluding object in front of it, so you're detecting the occluding object on the basis of those characteristics. I see. Okay. So in our submission, although it's true that one could leave that out, actually it's more precise to say what you're doing is detecting it on the basis of the combination of those two.
Could it be thought of as being, and I know it's not what it says, but based on an image property of the occluding object in the detection? Yes,
that's. I think that's just what I said to my lord. Yes. But that obviously imports a concept of both being used.
Yep. Thank you.
And in our respectful submission, that's obviously so, because what we're trying to do is create a mask of the detection image, ultimately, which then goes into the rest of the system. Did my lords have other questions on the construction point?
No.
So on amendment, well, really, we don't. We say that the judge was right for the reasons that he gave. That it was not necessary to make the amendment, and the core of the reasoning. There were various objections to the amendment that were advanced, and those objections were rejected. But the fundamental point that the judge concluded at paragraph 274, little Roman 2, that's 142 of the core bundle, is that the proposed amendments to the patent would be permissible were they necessary, but he concluded in 2741 that the patent was valid as granted, and so no amendment was necessary. And the combination of those points are points just on the procedural point raised, I think, by my Lord Justice Phillips on respondent's notice, was that because these points had already been appealed by the respondents, and because we were not seeking any different order or different to uphold the judge on different grounds, there was no need for a respondent's notice. We were saying the judge was right on all of these points for the reasons that he gave. Now, I can see that there may be circumstances which we say would be very unlikely to arise, given the judge's findings and what we submit will be the right outcome generally, where it may be necessary to consider whether this amendment should be permitted on the assumption that you find against us in relation to that point. But the point is already an issue because it's been raised by the respondents. And so that's the reason that there's no respondents. Sorry, the appellants. They're already raised by the appellants, and that's the reason there's no respondents' notice on this. It's because this is the way in which the judge configured the judgment and the order was made. It is true that in some of these situations where one is dealing with amendment and amendments put forward on a conditional basis, perhaps one could say the absolutely conventional paradigm case of respondents' notices and appellants' notices doesn't quite work because one's got fallback positions in patent litigation. But we respectfully submit that there's no need for that in this case, and the issue doesn't arise. But should it arise, the judge was right for the reasons that we've given in our skeleton in relation to the limitation, and in particular the key point on active that was pressed by a learned friend. I've really addressed my lords on that sufficiently.
It might, I suppose, not be so much a respondent's notice, which is another reason for making the same order, but a contingent cross-appeal, in that if the appellants succeed on their construction, you would say that the judge ought to have made the order which he said he was prepared to make if he needed to. But anyway, that's I'm sure that's an area
I'm bound to say
we
that,
don't need to get into.
I haven't thought about it in that way, and
your point is that the issue is in play.
That's the first point. The issue is in play. And the point of respondents' notices is to ensure that the Court of Appeal can consider the issues that are in play. It's not a purely formal point. Perhaps I might put it just like this. I would wish to reserve my position in relation to any procedural steps that may be taken should my lords come to a conclusion that made it necessary for this particular procedural point to arise. But I don't think it's sensible just to take up my lord's time debating that issue further in circumstances where it may not arise. And so perhaps I could leave that point on that
Yes.
On that basis. Can I then turn to infringement? And again, we don't really quite understand where my learned friends are coming from on this, bearing in mind the nature of the inventive concept, the scope of the claims, and so on. So perhaps I could just take it from the judgment and show my lords why we submit that the judge was correct. We can take that from the infringement section of paragraph 153, page 122, on to 170. Where the judge deals with the question of infringement in the way that we've really already articulated, and we respectfully submit that the nub of the reasoning in paragraph 164 is completely unimpeachable and follows from the construction that he gave to the patent. Now, there was quite a lengthy section in my learned friend's oral submissions about the signature and so forth, and how the system is alleged to work as a matter of fact. There's no dispute in relation to that for the purposes of this case. Once one construes the claim in the way that we say it should be construed, and as the judge construed it, there's really no answer to the point. It simply doesn't. All of these points, even if so, which in some cases may or may not be reflected in the PPD and the way in which the matter was articulated, are really nothing to the point. But we didn't detect anything that really engaged with that aspect of the argument at all. And that is why we respectfully submit that my learned friend was right when below the issue of infringement was conceded on our construction. Now, we put in a note on this, and again, I don't want to spend a lot of time on it. It's not a point that I place particular weight on, save to say that it was not a sort of per incuriam concession. It was on the basis of a position that was really not, the alternative wasn't really tenable. So the note that we submitted on the additional documents, which you may have separately, deals with this at paragraph 18. I don't think it's found its way into the appeal bundles. But you'll see what we have done by extracting that from the skeleton, and we give the relevant transcript references, all of which are in the bundles. We don't really detect that there was any answer to these points. We were criticised for drawing attention to this point, but then once we had drawn attention to it, there wasn't really anything that was responded to, and you can see the relevant references to that given in the footnote to that point, and probably the most relevant reference is at the supplementary bundle T3479. Where essentially, which is 236 to 236 of the supplementary bundle, where what was being submitted was, well, if it infringes, there is it's rendered invalid by the Nevity argument. Well, that argument was rejected. And what one's left with is the fact that actually it was accepted to be the case. And we say it was rightly accepted to be the case by the analysis that the judge gave to this issue in paragraph 164. And in fact, the vigorous note of objection, which says we're all completely wrong, actually effectively makes the same point as we've pointed out in our note, which is to say, oh yes, well, we accept that in certain circumstances that you've identified, this mode of operation will be used, and this will be true. But that is our point. And we make that point in paragraph 25 of our supplementary note, that essentially, even now, it's accepted that it's an example of a particular situation in which the point which AIM wants to make is true. Now, in our respectful submission, that really is the end of this argument. There is nothing that actually engages with these arguments on infringement. And the real underlying reason why there is nothing that engages with these arguments on infringement is because that is exactly what they've set up the system to work in exactly the way that our patent contemplates, for the reasons that our patent contemplates that. Because actually it is a good way of doing things where you've got illumination of the occluding object in front of a billboard, where you can selectively suppress in whatever range the relevant frequencies. So I'm not at the moment entirely sure what point I'm arguing against, because what we have here is a situation where, on any view, the facts are clear, the construction, if my lords accept our construction on this, is a clear one which accords with the inventive concept. The inventive concept is used, and it is used in accordance with the language of the claim, and it is accepted on the other side that there are circumstances in which that situation is true. So, subject to questions from my lords, that's really all I can say on on infringement.
I have a question. One of the things that Mr. Nicholson said in the course of this aspect of his submissions, and I'm going to do him a disservice, no doubt, and mangle what he said, but it certainly got this far in penetrating with me, was that there was an inconsistency between the judge's treatment of what it meant to say about detecting an object. I think this is the point that was being made, or certainly is what I understood it to be, because in some contexts, I think it was in relation to Navati, it was finding was that you weren't detecting an object, you were inferring its absence.
Oh, yeah, yes.
And that's different from detecting an object, whereas it's not really different in, and this is my understanding of what was being said rather than anything verbatim that Mr. Nicholson said. If you're doing effectively pixel processing, where you're looking at every pixel, whether it's background or not, including object, you're making a determination about what you think that pixel is based on its ratio. If you're talking about the infringing case or not, doesn't matter. You're always looking at them all, and then it all falls out that some level, some things count as background and something count as including object, and there isn't really a difference between detecting an object and inferring from an absence. And that I think is something that Mr. Nicholson was
I understand.
in this context. I have to say I don't quite understand how it fits into the non-infringement argument, but that is, I think, a point that's being made.
Yes, and can I answer that? Because there is a very short answer to it, and in fact the answer was given to my lord by Mr. Nicholson at a separate part of his submission, where you asked him correctly, so do you accept that in the infringing device you're detecting the occluding object by radiation from the occluding object?
Okay.
Because what you're doing is you've got this relative suppression, to which the answer was, after I think a little bit of pressing, yes. I'm being asked for the transcript reference, but in any event, perhaps that can be found if I'm wrong about that. So what the point is of the enhancement to the Navity system is that you are selectively turning one of the channels dark so that you can get light from the relevant occluding object. Now that is not an inconsistency in approach. That is a consistency of approach, because that's exactly what we're saying. It's not a question of inference in those circumstances. That is a question of detection. And indeed, that one can almost tell this, because why is this additional system used? Or when is it used? When the light is bright. No, that rather suggests that what you're doing is detecting from the objects, in this case the footballers, the light that is reflected from them, whether it be in this case in the IR range, so as to compare it with the channel that you've darkened. And you're obviously going to need, if you've got a system where you need to work out what the comparison is, some way of thresholding, and they did it by the ratio analysis. But the same concept is the one that's used. So the point that the judge was making here was, well, this is the same thing that's being done. It's not an inconsistency between inference and deduction. It's using the claimed invention in the same way as is contemplated.
Okay, thank you.
So again, subject to any more questions from my lords, I think that's really all I have to say on the issue of infringement. My learned friend will deal with the Navity OD issue separately. Perhaps I can just very briefly deal with the promptu point, which I got into a little bit yesterday. So again, we respectfully submit that the judge got this right for the reasons that he gave. My Lord Justice Males pressed my learned friend in relation to paragraph 270 on whether that was accepted, and I think ultimately it was not in dispute. But it is also important to remember that the judge's analysis starts on the earlier page at 262, where he makes particular findings relating to what was and was not admitted. And he says the gist of the argument is that AIM admitted that Claim 13 was invalid. So on, and he says that the argument is wrong for at least 3 reasons. First, there wasn't the admission that was made that Claim 13 was invalid if Claim 1 was, and we don't really detect that there is any appeal on the fundamental facts here. The judge found that it was a pragmatic concession, that there was no point in defending that claim. Second, AIM never admitted that Claim 12 was invalid if Claim 13 was. Maybe the conclusion was difficult to resist, but AIM did not formally admit it, even if allowing for its somewhat odd suggestion in its letter. Third, AIM never admitted that Claim 12 was invalid, and that's a point which my lords have put to my learned friend yesterday. And just following on from my Lord Justice Bursar's question as to what are you asking for? Are you asking for judgment on admissions here? Because formally speaking, one needs to analyse this matter in that kind of way. This would be an unusual procedure where essentially a party was subject to judgment on non-admissions, where the court found that no admission had been made in relation to what was then, in a sense, agreed to be the key issue, and the correspondence made clear that Claim 12 required resolution. And the judge said that it's not legitimate to combine admissions and matters said logically to flow to reach as a result, which was expressly not accepted by the party making the admissions. And we would reinforce that by reference to the facts as to what actually happened here. It may be that, as was debated during argument yesterday, that it was wrong to proceed on the basis of only Claim 12. We ought to have, or could have proceeded on the basis of Claim 1. And when I say ought to, I don't mean in that in a very general sense, but there was no real basis for going forward. And one might say, well, actually, the Nevity Plus situation indicates why that may be the right approach. And in all respectful submission, one simply doesn't get to a situation where there was any relevant admission that was one where any doctrine of approbation or reprobation could possibly apply. One's not dealing with a situation here in the context of trying to make procedural streamlines to a patent procedure of approbation or reprobation, when the key points in the case remain in issue in the case and are said to remain in issue by the parties, and indeed are agreed to remain in issue by the parties. And so once one appreciates that on those issues of fact, there is really nothing that can be engaged with on this appeal, we would respectfully submit that all of these points fall away. There was a big point made yesterday, which I have to confess I really didn't understand, on Section 72 of the Patents Act, which was debated with my Lord Justice Burse, where it was suggested that it was impossible as a matter of procedure, I think, it really went as far as this, for a court properly to make an order saying that a particular claim could be revoked if, for example, that was conceded as part of a PTR in the context of a larger dispute, without, not quite sure what the qualifications would be, without the court satisfying itself that in fact it was the case that the claim was invalid. If one tries to apply that situation to a typical case where most patents have multiple claims, and ultimately, well, perhaps I'm giving evidence, but I think it's probably a matter of common knowledge, ultimately at trial it turns out that only certain claims will remain significantly in play, and quite often it's the case where it's said, well, we accept that claims, usually we accept for the purposes of this case, or the purposes of these proceedings, that either something doesn't require separate resolution, or we're not going to defend claims X or Y, either on the basis of their fundamental validity, or on the basis of their independent validity from a main claim. If it's then said, well, because you have made concession X in relation to subclaim Y, it therefore follows that your whole case will fall in relation to the main claim. We respectfully submit that is unsustainable, and there's nothing in Section 72 of the Patents Act, or Section 74 of the Patents Act, that mandates that proposition. All those sections are doing is, as my Lord Justice Burst said, setting out limits on the powers of the court for the basis upon which patents can be revoked. It's not that it purport to deal with procedures for streamlining litigation, or what may or may not.
But it does mean that when an order is made, you know it must be for one of those grounds.
That's exactly the point. Yes, yes. But what it doesn't require the court to do is to get into what the grounds are. So let's suppose, for example, that the pleadings are advanced and it's said that a given patent is invalid because of the fact that it comprises excluded subject matter and is not novel based on whatever, and it lacks priority and therefore an intervening prior art affects it, and it's obvious over whatever the case may be. One knows that if a concession is made, it may have been made on one or other of those grounds. But one doesn't always even know that. I mean, as a matter of fact, that's the reason that it's made. It could be because people don't want to defend a particular claim for whatever reason, or because they find they don't have the evidence that they thought they might have to defend the claim. But that doesn't, or actually, as happened here, there are so many issues already in play in a case in a relatively compressed time. They want to get on with the substance of the case without risking the trial date, and so they say, okay, we're going to just focus on the things that matter. I mean, this was a case where the judge himself referred to the fact that this was a very compressed timetable for trial, and that actually there were a lot of issues that had to be grappled with. As I said yesterday, if one's going to get into a situation where if a patentee makes a concession for the purposes of a given case that they're not going to defend a claim in certain circumstances, that would actually make that kind of case management impossible to effect.
So it may also be worth, I don't know if this may or may not help at all, but it may be relevant, that you don't revoke claims.
Correct.
You revoke patents. You can amend patents to take out invalid claims, but you actually don't even have to do that. Okay, the court could, and has in very rare cases, but when it's been the right thing to do, left invalid claims in patents. I seem to remember doing it with, I believe Mr. Nicholson was one of the counsel in the case, actually.
Yes.
But I mean, normally, of course, you wouldn't do that. But it's not claims that get revoked.
No, that's absolutely right. And so, I mean, we would say that that marginally reinforces the point. The reason why marginally is because we really think that there's nothing in this point generally. And the reason why reinforcing is because what that shows is that it's even fine, in principle, to have a patent on the register which contains some claims that may be acknowledged to be invalid. Indeed, the cynic in the patent system would say that a large number of patents are on the register which have at least one claim which has something questionable about it, if one were to really shake the tree in relation to it. One can't have a situation where people are constantly being harassed for taking reasonable objections. May I just give one other illustration of where this kind of point may arise and where it's potentially quite important? If one's thinking about things like conditional amendments, where parties put forward fallback positions in contexts where they may not be sure as to what construction will be reached by the court. Let's suppose that someone says, well, actually, let's just try and streamline this trial. Let's not bother making this amendment a conditional amendment. We'll make it an unconditional amendment, because we don't really care. There's only one embodiment we're after, and that's the defendant's embodiment, and that's called by the unconditional amendment. Then one would be facing an argument that says, oh, well, by making that amendment an unconditional amendment, are you accepting that the claim granted is invalid, and if not, do we have to have an argument about whether that is or is not the case, rather than focusing on what the real issues are in relation to the conditional amendment? Are we going to, as I said yesterday, need to have an argument about construction of the correspondence in which that is done, or construction of the order in which an agreement to focus on the conditional amendment is then advanced before trial? Are we then, as in the case that I referred to yesterday, that Mr. Iverson was in, going to have an argument that, well, because the position has changed between, let's say, the PTR and the trial, having said, okay, we're only going to fight the case on this basis, it becomes necessary to resurrect a particular amendment because of what the other side has done. So, oh, no, we can't do that, because you're now stuck with this position. What it would make is impossible a situation in trying to streamline cases. So we respectfully submit that on this, the judge was right for the reasons that he gave, that the summary of what happened doesn't come close to a situation where it would be right to say that a patent that was otherwise valid and infringed, and indeed potentially where a claim where the parties had said, well, we're not going to debate that claim, was potentially valid on the basis of the findings of the court, should be regarded as essentially revoked and unenforceable against the world as a result of an attempt to streamline proceedings. That would be a very regrettable situation for the court to find itself in. And so, again, as with the amendment point, I will reserve any further points in relation to withdrawal of the non-admission, if I can put it like that. But the judge held, and we respectfully submit correctly, that there wasn't any relevant admission standing in the way of AIM defending Claim 12. Issue of withdrawal of admission doesn't arise, and he didn't need to decide it. And if it were necessary to decide, the Court of Appeal could make its own decision. So we respectfully submit that the right course in this case is to follow that approach. And I think I've said all I need to say. Prompt do. I think the transcript reference that I was asked for for today was T1, page 64 at 16 to 20. If I've got the substance of what the response was wrong, I'll be told, but that's what I understood as the submission being made. And entirely correct. I mean, it wasn't a concession. It was a rational answer from my learned friend.
Yes, all right, thank you. Well, if
So-
Mr. Nicholson wants to say anything about that, then no doubt he will in due course.
Unless I can assist your lordships further, those are our submissions.
No, I think we're going to hear from Mr. Cronin now, are we?
Yes, I mean, those are my submissions.
Very good.
Thank you, my lords. First of all, I may need to offer an apology. I may be sitting at the wrong bench. I've always been rather terrible about.
Don't
where I'm
worry,
supposed to sit in
it's
these.
quite a crowded room, and we're not too worried about it.
Yes, so I'm sorry. The alternative was sitting on my instructing solicitor, and I thought that would be this would be the preferable course. So the first thing to address is really when is this aspect of the appeal relevant? I went away last night and drew up a little table. There seemed to me to be 4 scenarios. The first is that Supponor were to win on grounds 1 and ground 2, then Nevity OD would be in play. If they were to win on ground 1 and lose on ground 2, the patent would be valid. If they were to lose on ground 1 but win on ground 2, then the patent would be saved by the amendment subject to ground 6. And finally, if they were to lose on ground 2 and lose on ground 1, the patent would be valid. So those in my head are the 4 scenarios. So without wishing to disparage the piece of the submissions with which I've been tasked, it is a point which arises only in certain circumstances. So if we could have the judgment to hand, my lords, we can take it up at paragraph 205. The argument, as we've heard, was that it would be obvious to enhance the system in the Nevity prior art using these CGK object detection techniques. And we say that the judge's analysis on this was entirely correct, and that he summarised the evidence and arguments at 205, 215, succinctly but effectively. And indeed, he took into account Supponor's points and accepted the force of some of them at 213. So this was your classic obviousness case where there was a balancing exercise between the parties' evidence and submissions. He found that in relation to Supponor's case that the Ames points in response were more powerful in the end. And he records that at 214, where he says the fact that Nevity is a simple solution that would be expected to work goes against it being obvious to add a layer of complexity. And ultimately, he concluded that Supponor's approach was really too vague to support a finding of obviousness. We say that was clearly correct and certainly open to him on the evidence. So that there are 2 aspects to the grounds of appeal. The first is an allegation that the judge has misunderstood the nature of the problem. We can get this one out of the way first. This relates to 1862 of the judgment. Which we find at the top of the core bundle, page 128. And the judge records the problem there of the system of figure 3 of Nevity, which we saw yesterday, might present practical problems of identifying the billboard and distinguishing it from its surroundings in conditions of bright ambient sunlight. And we've heard plenty about that already. Now, we say it's somewhat surprising the judge is criticised for identifying that as being the problem. This was almost exactly the same as Dr. Thomas, our expert, said in his evidence at paragraph 126, and we can see that at sup, page 138. And that comes halfway down his paragraph 126, if my lords have that. So we can see on the 5th line down, he says, for example, the skilled person would understand but increasing the brightness may be necessary to allow the billboard to be detected and distinguished from its surroundings in very bright ambient sunlight conditions. So the judges here are very much following the evidence, and indeed he's actually also following the prior art, because this is very much the way that Nevety talks about Nevety's invention, keeping in mind that it's really the patent introduces the idea of detecting the occluding object. So it's not at all surprising that when we're talking about Nevety, we're really focusing on the billboard. And we can see this in page 2 of Nevety at Sup, page 24. And it's the second paragraph. At the end of line 10, we see a lone A, and that starts the sentence. A camera observes the subject to provide camera video images. At least one detector unit also observes the scene to derive a detector signal relating to the radiation from the subject to thereby distinguish the subject from its surroundings. And we see at the top of that paragraph, in one embodiment, the subject is a billboard. Nevety, all about detecting the billboard, using the radiation from the billboard to distinguish it from its surroundings. So to say the judge misunderstood what was going on here, we say was really not quite right. And indeed, when we think about the surroundings as encompassing, for example, potentially occluding objects, when we're taking our step back from being the skilled person looking at Nevety, who isn't aware of the patent approach, we know that Dr. Thomas's evidence certainly encompassed the occluding object within surroundings, and we can see that from his second report, paragraph 48 at Sup 148. And he's referring there back to paragraph 126 of his first report, which we've just looked at. And he says there, starting to read halfway down, the skilled person would address the issues by increasing the brightness or intensity of the IR signal and or applying a threshold test. And he says they would do so in order to better identify the visible parts of the billboard. That is, the non-occluded parts of the billboard. So that was the evidence which stemmed from the way the prior art looks at the problem. And we say, therefore, the judge's identification of the problem is really spot on. And the judge himself, in fact, commented on this when he was giving permission to appeal. And that can be seen at in the core bundle at page 147. And this is the judge's judgment on permission to appeal, where he's dealing with the various grounds. Ground 4, he says, is the erroneous approach to obviousness, and he comments that much of what is said in support is not an error of principle at all, but simply an attack on his assessment of the evidence. But he says there are two problems which have caught his eye. The first one is the one we're discussing now, which is that it said that he erroneously stated what the experts agreed the problem was, because he didn't refer to the occluding object. And he says specifically, that seems to me a weak ground, because clearly when I came on to deal with the substance, I do refer to matters which make it clear that I had in mind occluding objects. And you can see that in paragraph 212 of his judgment, he says. So we say the underlying evidence took into account the presence of occluding objects. The way that paragraph of his judgment was phrased simply reflected the way the skilled person reading Nevety would be thinking about things, and indeed the judge's assessment of the problem was based on the evidence, and it can't be faulted on that basis. So, my lords, that's the first point about misidentification of the problem. The second question on Nevety OD is about the judge's wider decision about obviousness and application of higher order image processing. That analysis needs to bear in mind the context in which the skilled person is coming to things, and that is a context in which the Nevety document is not really about this. And the judge made a finding to that effect at paragraph 174 of his judgment. Nevity was really about content selection. It was about deciding what you want to put on your overlay billboard and how you're going to arrange it. That's a finding at 174. And just for your note, the underlying evidence for that was Thomas 1, paragraph 125, which is at Sup 138. So that's not in dispute, that Nevity is really about the selection of replacement content. And we can very quickly glance at the figures in Nevity just to understand what that means. We can see those in Sup 47 onwards. So we can see in figure 4, you've got a sort of a zoom adjustment system where, depending on how zoomed in you are, you might want different content showing up. Then in figure 5, it's all about where you put your replacement content. And then over the page, in fact, let's skip to figure 7. Figure 7, you have an idea about using the focal center of the camera and then adjusting the replacement content to look towards the focal point of the camera. In this case, providing some slightly, some slightly creepy eyes, kind of following the player around. So it's this material which the judge found to really be the focus of the pattern. So that's an important background, we say, to the research exercise which the other side relied on for their obviousness case. The second bit of relevant context is figure 3, which is that we've been through yesterday, so I'm not going to take you to that again. But in all of this, there's no suggestion anywhere of any kind of higher order processing. So that's Nevity, and so the next step is, well, what does the skilled person do with it? Now, the obviousness attack at trial was never put as in the way Mr. Nicholson, my own friend, put it yesterday, where the skilled person sits at their desk and has a kind of an idea or fills in blanks. It was really suggested to be an experimental process. And this was really, as we point out in our skeleton argument, based on the evidence of Professor Steed. And I think it's necessary to turn that up at page 164 of the Sup bundle. So paragraph 236, Professor Steed says that this would involve development work and practical experimentation. And he goes on from paragraph 239 to explain a bit about what he foresees happening. He describes it 241, a proof of concept and a prototype hardware setup. 242, he talks about producing custom-made hardware in collaboration with a third-party manufacturer. And importantly, at the end of 242, he says this would be an iterative process in which issues were identified and ironed out. So this is the factual premise of the development program which is being undertaken here. And we add the point in our skeleton at paragraph 79 that in his oral submissions, Professor Steed confirmed that this was the kind of development process where the simple approach would be tried first. And only if proven not to work would the skilled person move on to something more complicated. As we say, that's very key underlying material for the judge's conclusion that some concrete problem would need to arise. Because if you're doing an iterative process, that's inherently one which is driven by finding problems and solving them. The next bit of Professor Steed's evidence over the page provides context for the judge's observation that everything was just too vague. And we can see that 244, Professor Steed talks about his initial design choices. And this is the language in which his whole section on obviousness is really couched, where he says that he's just going to discuss some examples of choices which might be considered and the choices would depend to some extent on requirements. But there was never any sort of real thrust to this. It was just a selection of options. And so we see over the next couple of pages a large variety of options. We see infrared and visible light detectors, ultraviolet detectors, polarized light detectors, multiple detectors including stereo imaging processing and other things of that nature. And we say this was all too abstract. Now, the next thing to keep in mind is that this avenue of development is not a one-point goal of higher order processing, because there was, of course, the other aspect of the claim that was missing, which is the requirement for an LED billboard. Because Nevity is all about kind of backlit printed sheets. And so the other side had to establish it would be obvious to move to an LED billboard. Now, Dr. Thomas agreed that that would be a desirable goal, but it has to be kept in mind that when you're considering whether it would be obvious to end up down an avenue where you introduce higher order processing, you also have to be going down an avenue where you're designing and custom building a new type of billboard, which no one's ever produced before, which at least the skilled person is not aware of, which has an extra infrared emitter. So you've got and Professor Steed describes this from 258 onwards. And in particular at 264, where he says that an integrated IR illuminated LED billboard would be seen as desirable. And they may not have the expertise and equipment to make one themselves, but they wouldn't see an apparent technical barrier. And so the skilled person is sufficiently motivated, apparently, to go and produce this very specialist billboard to emit a powerful IR keying signal. And we would submit that's somewhat inconsistent with the idea that they're also going to go down this other route, which they must prove is necessary on obviousness. And the kind of interaction between these things was never really puzzled out, and that's one of the reasons why the case was described as vague, because it wasn't a sort of concerted push towards a particular embodiment of the kind that you really need to be making on this sort of obviousness case. While we're here, I should point you specifically to the relevant paragraphs on mask generation, and that's paragraph 269. Now, 269A is the simple thresholding approach. That's not higher order. B to D in 269 are higher order, accepted to be, and so it was necessary for, amongst all of these different options, for Supponor to prove that the skilled person would alight in that B to D range. Now, we accept that these are sort of CGK techniques. A little bit of care needs to be taken with that, because the CGK was not, these are great, everyone loves them, everyone always uses them. The CGK was, people know about them, but it doesn't mean they always think it's a good idea to do them. And in the judges section on the common general knowledge, there was discussion of the potential drawbacks of various of these techniques, including the sort of additional computation power, the potential for them to mess up, and the fact that they might not be applicable in certain circumstances. So a little bit of care needs to be taken in that it's not, we would say, a case of something CGK, therefore you can always go ahead and do it. It's a contextual analysis where you have to look at what is the actual problem that I'm solving, and why would I think this particular technique would be the right approach? And that, again, is part of the vagueness problem that the judge identified, where particular techniques have drawbacks and advantages and would be good for specific things. An obviousness case where you just say, well, you do one of them, we say isn't good enough. There needed to be something more concrete. So the sort of final area of sort of the material in the case, which we say was vital to the judge's conclusion, was the evidence of Dr. Thomas. Now, he was the only witness who had actually worked on video overlay systems for live sports broadcasting, and we've explained in our submissions that his view, which was paragraph 65 of his first report, was that the simple thresholding approach would work in practice. Now, it was suggested yesterday that Dr. Thomas did not disagree that higher order techniques would occur to the skilled person. But if that is really what was said, then I'm quite sceptical about that. And just to make sure that there's no misunderstanding there, I think it would be sensible to turn up 151 of the supplementary bundle, just to make sure that the court is appraised of Dr. Thomas's written evidence on this. Sorry, in fact, we could start at 150, and I'm just going to run through the relevant paragraphs quickly, so my lords have them. I'm not going to read them all out to you in the interest of time. So the first relevant paragraph is 60. There's no suggestion technique should be used. It criticises the theoretical manner. Then there's 65 and 66, Sup 151, where he says there'd be no reason to consider the application of such techniques in this context. Again, more at 82 and 83. 82, he says the implication from the discussion in Nevity is that the mask would be generated based on thresholding. And then the final point is at 111, where he says there is no teaching in Nevity which would suggest to the skilled person the use of higher order image properties. So, but to the extent it was submitted...
Paragraph reference for that again?
Sorry, 111, my lord. So to the extent it was submitted that Dr. Thomas agreed about the higher order techniques, we say that's plainly not right. And furthermore, Dr. Thomas's evidence at trial was that if they exhausted the brightness approach on the infrared LEDs, what they would do was they'd add another detector signal, because that's what Nevity actually teaches. It's actually teaching in Nevity. And as we've seen, Professor Steed also suggested you might want to have another detector signal, i.e. ultraviolet. And so that you can see that even if one starts getting to these secondary, tertiary, whatever avenues, it's not the higher order processing one that's looking promising, because that's not one on which the experts actually agreed. There was the point about the fact that both experts perceived a problem. We don't disagree with that. However, as my Lord Justice Burst noted, it was a provisional one. And we would say the key question is, was it a problem to which higher order processing was the answer? And we say no, it was a problem to which trial and error experimentation was the answer. And we can see the judge found this in terms at the end of paragraph 217. Oh, apologies, by the way, that's a bad reference. 197. He said, the cross-examination overall gave me the impression the situation was relatively complex. To the extent a concrete problem turned up in due course, Nevity did not offer a clear way forward to a definite solution. Rather, as often seemed to be the case in this field, trial and error would be necessary. So he's saying this is a problem which you get into with trial and error kind of experimentation. That's what Professor Steed said. He said it's an iterative process. And that's why we say this isn't an error of law kind of situation at all. The judge's decision that a concrete problem was required arose entirely based on the nature of the factual obviousness case put forward, which was an avenues of research type case. And in that situation, the judge was entitled to find, as a finding of fact, that some concrete problem would be required before higher order processing would come into the mix. And so when the other side say, you can't conclude that as a matter of law, we say, that's not right. This isn't an error of law. It's not a finding of law. It's not the application of law. This is just the facts of their obviousness case, which didn't fulfill the requirements which it should have done. And we therefore say it's unsurprising the judge held that higher order processing would not be considered unless some issue were to prompt it, and that this was the classic multifactorial obviousness evaluation, which the Court of Appeal should be reticent to get back into, because it was all heavily evidential, and therefore the trial judge was really in the best possible place to do the running on this. So well, those are my submissions on the Nevity OD case. That gives us, unless there's anything from behind. No, well, in that case, it's
Thank you very much, Mr. President.
my pleasure.
Yes, Mr. Nicholson.
My lord. My lords, I'll keep my reply relatively short. Hopefully we can finish by the short adjournment or within a few minutes of it.
Yes, very good.
What's come through from my learned friend's submissions is the importance of ground 2 to this appeal. It's become clear that the way that my learned friends view matters, from what my learned friend Mr. Cronin was saying a moment ago, that they consider that Nevity object detection is pointless insofar as the claims still require the dark billboard. So it only arises if I succeed on ground 2 and on the amendment, which is ground 6. Now, just taking that approach as read, forgetting about pixel by pixel processing, forgetting about any argument that you must have a dark billboard if you're trying to implement pixel by pixel processing. Let's look at the ground 2 point as to any no dark objects on a white screen. As we've explained to your lordships yesterday, there is nothing in the claim about any particular type of screen, one that is inherently dark, and our red LEDs on white billboard is wholly inside the claim. And it was notable that my learned friend, Mr. Alexander, didn't seek to engage with white billboard backdrop with the red LEDs on. He knows it's within the scope of the claim. He's got no reason to say it's excluded. And any attempt to construe 12.3.1 as meaning that all light emitted or reflected by the billboard must be excluded from the detection image is wrong. My Lord Justice Phillips raised this issue with my learned friend because it's a point I was clearly making. It's absolutely squarely in the words of integer 12.3.1. And with respect to my learned friend, a rather ambiguous answer was given. The light which must be excluded is that from the moving images and no more. And the same goes for the not active amendment that my learned friends tabled in respect of ground 6. There's just no reason for the exclusion, no basis in the teaching of the pattern or the words of the claim. No reason to exclude anything other than the requirements that are put there. And my learned friend's position on Nevity object detection really illustrates the problem. Now, assume for a moment, not as a question of obviousness, just assume that somebody builds Nevity object detection today. Assume they use moving billboards, just as everyone accepted you could when building Nevity. The moving images would be filtered out by the infrared cameras, so as not to appear in the camera or detection image. In the detection image, just as taught by the patentee. The billboard in the detection image would be monotone and uniform, just as taught by the patent, because the moving images would be filtered by the infrared camera which Nevity had. Now, I've conceived that we've added full object detection using one of the algorithms mentioned in the patent. The result is that we've taken the whole of the patentee's teaching. We've produced a system which uses full object detection that allows us to have moving image billboards in the ground and that don't interfere with the detection process. So the question arises with this newly built system, does it infringe? On my client's construction, it fairly falls inside every integer of the whole of Claim 12. On AIM and the judge's construction, it doesn't. And why doesn't it infringe? It doesn't infringe because it has a white billboard in the camera image instead of a black one. Yet there's nothing in the patent or the claim to support such a limitation, either express or on a purposive basis. Respectfully, we say that it illustrates strongly why we're right on ground 2. There is no proper exclusion of dark on light to be implied into the claim. And if we're right on ground 2, and for the same reason amendment, our ground 6, it doesn't help AIM. The patent is invalid over nevity without modification. If object detection is broad enough to cover pixel by pixel, as the judge held in paragraph 26 of the judgment. Now, obviousness over nevity object detection isn't needed, and infringement doesn't arise because the patent's invalid. Likewise, our promptu ground 5 is irrelevant because the patent is invalid for other reasons. And accordingly, I would invite your lordship to give careful and separate consideration to ground 2 first, because it really does bring us to the nub of this appeal. If your lordships are with me on ground 2, all the other grounds effectively fall away. What reason is there putting pixel by pixel type arguments and the like out of one's mind to limit claim 1 to requiring a black screen? There's none, we say. In addition to that general point, there's 7 or 8 very short points that I pick up from the various speeches. I take them in the order that they arose, so with apologies that they appear isolated and nebulous. My learned friend was seeking to say, by showing your lordships, that figures 5A and 5B were being pushed around at trial, that we were looking at it and they really aren't saying anything different. None of the material that my learned friend showed you actually supports the point that's made in my learned friend's written skeleton, which is that the correct interpretation of figures 5A and 5B is that the flat lines between the peaks is telling you that the screen must be not reflective. That's the point made in my learned friend's skeleton. It wasn't advanced orally, and it's a new point over trial. That's an emission spectrum. It's telling you what's being emitted from the display and nothing about its background properties. My learned friend spent some time with the PPD out and referring to the figure in the skeleton. Somewhat surprisingly, he said several times, and we agree with him, this doesn't matter for the purpose of this case. This is the very point I raised with some caution yesterday, that it is really relevant, so I understand, potentially in Germany. And I ask your lordships not to be drawn into interpreting the PPD and making decisions outside of what the judge has already said about the SVB system. My learned friend acknowledges it doesn't matter for the purpose of this trial. I don't want to waste time with my lords telling you about the dispute that's going on in Germany and asking you to construe matters that aren't properly before you. My learned friend on construction of Claim 12 made brief reference to Claim 2. It's a point that's made more, that was made in the judgment. There's 2 issues that arise with this. The first issue is there is no Claim 2 anymore. It's been deleted. It was never a dependent claim from Claim 12. Claim 1 has, unsurprisingly, Claim 2 as a dependent claim. But that entire claim chain has been deleted from the patent. So it's improper, whether it was or not at trial. It's certainly improper now to use Claim 2 as an aid to construction. But there's a second issue that arises with it. And the problem with Claim 2 and why the analysis doesn't work is that there's 2 integers introduced in Claim 2 And it's perfectly easy to say that when claim 1 is something to, for example, vehicles, and claim 2 adds in wheels, to say, well, claim 2 is to vehicles with wheels, that suggests that claim 1 might be broader. But if claim 2 introduces 2 separate features, motorized vehicles with wheels, it doesn't tell you what the full scope of claim 1 is. It doesn't assist as a guide to construction. And here claim 2, I'm looking at the German version, here claim 2, which is in the core bundle, supplemental bundle at tab 1, page 10, adds in the image property of the occluding object relates to a descriptor of a neighbourhood of pixels, wherein the descriptor comprises a spatial frequency, and wherein the detector is configured to compare a descriptor of a pixel of the detection image to the descriptor of the occluding object. So it's got 2 features, and one doesn't know how that relates back to claim 1. So we say claim 2 of no assistance.
Just going back to your earlier point that claim 2 can't be taken into account as a matter of construction of claim 12 because it's now been abandoned and deleted. That strikes me as a little bit odd. I would have thought, as a non-specialist in this area, that the patent has a meaning at the time that it is issued, construing it as a whole, and that at that time, reading the patent as a whole, if claim 2 helps you to discern the true meaning of claim 12, then that is a legitimate thing to do. But if it ceases to be legitimate once claim 2 is abandoned, that potentially means that the meaning of claim 12 changes, which seems surprising to me. Is there any law on that?
There is, my lord, and it's the case that my Lord Justice Burse referred to. It is the Nintendo case in which I appeared in front of my Lord Justice Burse at first instance. In that case, there were 2 claim chains, and my lord came to a construction of the second claim chain based by comparison to the first claim chain. My lord, Lord Justice Burse found the first claim chain, I'm doing from memory, invalid, and the second claim chain valid when interpreted against the invalid claim chain. They went off in different directions. After trial, the patentee sought to delete, as would be the usual course, the invalid claims. An objection was taken by my client that, exactly as my Lord Justice Mayle says, if that results in a new interpretation of the additional claim chain, then we've got a problem. And this was actually the unusual circumstance which, after a number of interim hearings, Lord Justice Burse decided that in the circumstances of this particular case, both claim chains would remain on the patent register, but a caution would be added to the register, noting the invalidity and the non-assertion of the first claim chain. And the reason one ends up in this situation is because, unlike a contract or something of that nature, when claims are declared invalid and revoked, they're revoked ab initio. They go for all time. So even when we roll back to the date of the patent when it first appeared, they're deemed as a matter of law not to be there. So we do say one has to be a little bit careful with claim 2, because if one does take it into account, then you end up potentially in the Nintendo type situation.
Yes. All right. Well, that's very educational. Thank you very much.
I'm grateful, my lord. Yes.
You didn't take this point before, Mr. Nicholson, did you? This point that you just made about claim 2, it wasn't raised in your skeleton, I don't think.
No, I don't believe it was, but it was notable. But I don't think the claim 2 point was taken by my learned friends in their skeleton, I think I'm right in saying. So I thought it had gone for very good reason. If I overlooked something in my learned friend's skeleton, I apologise, but I didn't deal with it yesterday, and I didn't deal with it in my reply skeleton because I wasn't aware that my learned friends were seeking to support that aspect of the judge's reasoning. If I missed it, I apologise, but my lord is absolutely right that I don't make that point in my reply skeleton. Yes, my learned friends are very keen to emphasise that there's no, the discussion we had yesterday, that there's no teaching of the use of radiation, radiation that is, I think, emitted from the billboard in the discussion I had with the court yesterday. The problem that they meet is, the problem that they make is there's no teaching of any types of use of radiation in the pattern. What the pattern is about taking camera images. Camera images are always formed by radiation. And it's interesting, actually, in 12.3.1, that it's actually, the camera is configured to be able to detect radiation having a frequency outside of all of the more predetermined frequency bands. It doesn't say there has to be radiation outside of those bands. So the fact that the referee's trousers are black doesn't mean you get radiation from those trousers. So one has to be careful about saying there's no teaching on the use of no radiation, but there's no teaching on the use of radiation as well. And this is where there's a processing difference between 12.3.1 and 12.5. 12.3.1 is taking an image and it's telling you what the frequency characteristics of your notional filter are. You take the picture, what you do with it comes in at 12.5. Moving on to integer 12.5. My Lord Justice Burris was asking my learned friend, as he asked me, about image property of the occluding object and the detection image. Whether I said it well yesterday or whether I didn't, I was trying to say it in the same way as my learned friend, in that you're using two things. You're using the detection image, which is what you've collected with your camera, and you are then, as a starting point, and then you are using the image property to find something within that image. But that isn't the same as based on an image property in the detection image. They are two different things. It's not just telling you to use the detection image, and it's not just on an image property. It really is the two inputs to the object detection process. Here's my image, here's my descriptor, here's my object properties, and I'm using that to help find things in the image. So it's those two parts which are expressly there in integer 12.5. And if one tries to read it as based on an image property of the occluding object in the detection image, you're throwing away, to some extent, one of those inputs to the system. Oh, yes, yes. Sorry, I was trying to understand my own note. I apologise. The difference between inferring and detecting. This does arise in the judgment. I pointed it out in Core Tab 8. It's paragraph 141. And it's the judge's sub 7 on page 121 of the bundle. In a dark on light situation, one would naturally say that the presence of the occluding object was inferred, but one would not say that it was detected. Now, if one takes that construction, and the judge did use it in the context of nevity, to say at best nevity infers the presence of an object, because we all know what you end up with at the end of the day after you've done the process is the system has managed to distinguish between objects on the one hand and the board on the other. That's what all of these processes are trying to do. But the judge's view was there's a distinction between inferred and detected. Nevity infers, suddenly we're told the SVB system detects. And we say we can't reconcile that approach. And that is part of our core aspects on infringement. And we make the, I don't understand, my learned friends, to have a full answer to that. I don't accept that any concession was made. I say that reading the total of the extract that's on of the transcript that's on the back of my learned friend's additional note is fair and correct in entire context. One's in a discussion with the judge and one's trying to respond to the points that he's making. In the early part of the transcript, which my learned friends have set out, I'm setting out what my case is, and then the judge is asking me whether he has correctly understood Ames' case. And I say, yes, that is the case, and that is now being taken as me agreeing with AIM as to its case. With respect, parsing closing speeches in an attempt to try and find a concession that my client actually completely gives up on its infringement case isn't the proper way to determine issues between the parties. Prompt you. We need to be careful about Claim 13. My learned friend, Mr. Alexander, showed issues about Claim 13. There was a dispute about Claim 12. There was a dispute about a concession over Claim 13. I am not appealing the Claim 13 point. Neither is my learned friend, because actually it was decided against him that looking at all the concession, he wasn't allowed to keep Claim 13. It fell away. The point about Claim 1, which receives very little attention in the judgment, is different. My Lord Justice Mells was asking me about paragraph 270, about whether it would be unjust. It is about Claim 13 at that point, and potentially there's an unjustness arises when one is construing concessions. When we come to Claim 1, it's not unjust. It's no more unjust than when a party misses the Limitation Act by a day. It might be hard, but sometimes the law is hard. And it may not be what, in this case, the patentee intended. But you've got to take the consequences of your actions. And with respect to this, the admission was made that Claim 1 was invalid in the light of nevity. I've shown you by section 72 that revocation can only occur when the court is satisfied or sufficiently satisfied that a ground has been made out. And my Lord Justice Burse made the point this morning that in fact claims are never revoked as such. It's a patent as a whole that's revoked, and a claim rather goes through an amendment. And my Lord Justice Burse was right to make that point, because if one turns up the order of Mr. Justice Mead at tab 7 in the core bundle, and page 86 of the judgment, the court in fact dealt with it by making a declaration at paragraph 2. Claims 1 to 11 and 13 as granted are invalid. And then the paragraph 4 to put this into effect and order that the patent be amended so as to delete claims 1, 11 and 13. So my starting point as a matter of absolute clarity is that there is a declaration of the court, and my lords will well know the courts don't make declarations by consent. The court has got to be sufficiently satisfied to...
This one was.
Sorry.
It says so in the recital.
Well,
Last recital on page 84.
sorry, I pulled the wrong bundle. I don't doubt my lord at all. Last recital on 80.
Page 84.
Yes, so the claimant has consented to the declaration, it's not disputing it. And that's the claimant, that's AIM Sport, the patentee. They're happy for it to be made, but it's not consent as between the parties.
What do
The
you
court-
mean you didn't want it?
I'm not saying I didn't want it, but the declaration, my lord, the point I'm making is the court has made a declaration about the invalidity of the patent. And the way in which my promptu point runs is that having accepted for the purpose of the declaration that something is invalid, turning around and saying the same technical subject matter is valid is approbating and reprobating. Exactly the scenario that my learned friend, Mr. Alexander, said he wasn't doing. I say he clearly is. And the consequences from that flow. It may well be the case that parties give acceptances at trial and in the run-up to trial that they will only rely on particular claims and matters of that nature. That's all perfectly normal procedural approaches. It's actually extremely unusual for a patentee to say that they accept that this claim is invalid. And in fact, when it happened in the promptu case, which is in the authorities bundle before the court, in those circumstances, Mr. Justice Mead said that they couldn't be heard to say later that the features of those claims, insofar as they were folded into a subsidiary claim, were valid, were validating features. They'd admitted they were invalid in the light of the prior art. And we say you apply the same here. But in this case, instead of having additional integers, because we're talking about a subsidiary claim, here we're talking about a case where the integers are the same, and the parties on both sides say that they are, there's no technical distinction between them. I only have two short points on my learned friend Mr. Cronin's submissions. My learned friend Mr. Cronin clearly said, when discussing Nevity, that Nevity is about the billboard. It's the patent that introduces detecting occluding objects, was the way he presented it. I'm sure that's not a perfect quote, but that was the point he was making. We say quite so. That is absolutely our point here. The patent introduces something different, that thing which Dr. Thomas considered to be technically and conceptually different. Even though you're ending up with the same picture, the same image replacement at the end of the day, you're going about it in a different way. The patent says, go look for the occluding object, don't go looking for things like Nevity do, the billboard. And we say that that has got to be properly encapsulated in the construction of the claim, where the claim says detecting objects based on the image properties of the occluding objects and the detection image. It means based on the image properties of the occluding object, not based upon the image properties of the billboard from which we will infer the occluding object. That is the essence of the difference between what went before, what went after, and the patentee itself, and it's proper that it should be reflected in the claim construction. Then finally, the final comment on the overall approach that my learned friend was taking to the Nevity object detection obviousness case is it's important to bear in mind that when experts sit down and write their expert report in a patent case, they are not required, but they are ideally set that task without knowledge of the patent. There are ways, sometimes with knowledge of the patent. In this particular case, both sides' expert attempted the exercise of setting out what the skilled person would do with the prior art and make clear in their expert reports that they hadn't seen the patent yet. They don't know where they're going. And the reason that's done is to avoid hindsight. The result of the consequential evidence is you don't shine a bright light, in most cases, on the final destination. It requires the expert to sit there and, as best as they're able, to say, well, look, I'm sitting here looking at this. What's the breadth of reasonable, uninventive ways of taking this the skilled person might take? And it's unfair, subsequently, we say, to come back and look at their expert report that's got 3, 4, 5 different ideas, each of which they consider are obvious, that don't involve an inventive step, and say, well, it's all very diffuse. The expert isn't hitting the nail on the head. Where is he going straight to image detection? And of course, in the normal event, any skilled person, any scientist, any engineer, will prefer, when they come to the implementation stage, to try the simpler ideas first. But the fact is, sat at the desk, the skilled person, just like our expert, sat at his desk, hadn't done any experiments on Nevity, hadn't done any investigative experiments, sat there and said, well, Nevity, I can see a potential problem here, put it at that level, a potential problem. What would the skilled person do about it? And if they land on the patent, then that's enough, we say, to invalidate the patent. My lords, unless there's anything else which I've failed to deal with, those are my client's submissions.
Thank you very much. We're going to reserve judgment. In due course, judgments will be supplied to you in draft for the correction of any typographical or minor factual errors. The draft will come with an embargo on its front page, which, as you know, the court takes very seriously. We hope and expect that, in the light of whatever we decide, you will be able to agree a draft order for our approval. If you find that you can't, then we will have short written submissions and deal with consequential matters on paper. I think it only remains for me to thank everybody, both all the legal teams, both those who've spoken and those who haven't, for the assistance that you've given us. That concludes the hearing.
All right.